come before the court this morning is UBS Financial Services versus LaCava Jr. Are all parties here today?
Yes, sir.
You want to expect anyone else?
No.
Okay. Each party will have 15 minutes in which to present the case. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and you wish to reserve that time, please let me know because I'm keeping track of the clock. I will keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read your briefs and we're ready to proceed when you are.
Your Honor, Mayor, I filed a petition, a motion,
But,
not having.
yes, before we begin the oral argument, I want to address a pending motion. Mr. LaCava, you filed a motion asking this court to not record this oral argument. UBS has 10 days to respond to that motion. The 10 days don't expire until tomorrow. The oral argument will be recorded today, but we're not going to post it until the court decides that, which will happen next week. We'll decide the motion next week. If the motion is denied, the court will post the oral argument video as it does in every appeal. If the motion is granted, the court will delete the oral argument video without posting it. Finally, as in all cases, all parties should avoid discussing information that could be embarrassing or subject to confidentiality agreements. Okay? That's all your issue?
Thank you.
Okay. You may proceed.
Thank you, Judge Schaefer and other members of the court. I'm Albert LaCava, and wanted to focus this case on misinterpretation by the trial court of the law and the misapplication of the law. 132 Ohio legislators, one governor, had mandated in law that every Ohio citizen, Ohio resident, has property that is exempt from execution and sale. And in the Ohio Supreme Court, Dennis versus Smith case, made it clear that the primary protection of the family is the goal, and decisions regarding those household items are to be in favor of the family. And so I would ask the Honorable Court to reverse the sheriff's sale that the trial court ordered because it didn't follow the law. There were no appraisals, which is Ohio statute requirement. They legally tag my wife, Mary Ellen's 100% owned items per affidavit to become joint. By what legal authority can they do that? Number three, they ruled on exemptions incorrectly. And fourth, they denied Mary Ellen, my wife, her due process. The second item that I would ask the court to do is to declare all the items in the inventory listed as exempt. They're primarily held for personal, family, and household use, as defined by the exemption statute 2329.66. I like to crystallize one example: kitchen chair, simple household good. Obviously, it is a household good, but the trial court said it wasn't. How can reasonable minds together come to one conclusion, that it's a household good? And we can go through the entire list and exercise the same logic and reasoning and come to the same conclusion. They're all exempt. Number three, reverse the trial court's illegal tagging of the 24 household items that my wife filed in her affidavit, that she claims she owns 100%, and that the trial court tagged as joint owned. Again, no explanation, no legal authority, and she wasn't even given due process to defend her claim.
Is there something in the exemption statute that applies to co-owned property?
Thank you for the question, Your Honor. Yes, if you please take a moment and look at the case that I filed as a supplemental authority, the Steimer case. They're required to use Ohio law. They specifically address a husband and wife debtor and the exemption, and in that case, there's no argument that they both get the exemptions. And so what would be an aggregate amount of $12,250 per household items, the court agreed that it's $24,500, just times it by 2, therefore answering your question that both husband and wife each individually get the exemption. Number 4 is to remove Mary Ellen's 24 household items from the inventory list. UBS has no money judgment against her.
I ask a question. Are these 24 items sold solely owned by her?
Correct, as is stated in
Can
her
you
affidavit.
explain to me how you have standing to argue her claim?
Because he, the judge, declared those as joint. And now they're open for execution and sale, and therefore, they're part of my property according to him, and therefore I'm defending the truth and the evidence in that case. He misapplied the law.
But what you're arguing is that you have no claim to them, that they're hers.
Correct, but as it stands today, the court has says they're joint, and therefore I'm speaking as a joint party, and that's my authority.
But how have you been harmed? They're hers.
If the court order is carried out, will be greatly harmed, and Ohio law will be violated.
No, she'll be harmed, but how will you be harmed? Because you're saying this is her separate property, right?
If you look at the Dennis and Smith case, they say for husband and wife, it's irrespective of title. And based on that, given that we enjoy the items together, it does harm both of us.
I was just going to the standing question.
Number 5, grant the statutory dollar amount per item, which is $575 per household item, and the aggregate is $12,250 each for Mary Ellen and myself. And together, that would entitle $1,150 per household item and an aggregate amount of $24,500. Again, referring to the Steimer case, which was filed this week, and all the parties here received it.
But may I ask a question about that? That decision came out in July of 2016.
Yes.
It wasn't anything that came out from the time you filed your complaint, your appeal.
Correct.
Okay, and you did refer to it in your main brief.
Because my brief was filed after this case was presented to the public.
Right, and my point is that you didn't cite to this case when you wrote your brief.
I couldn't because it wasn't available.
Well, it's been out since July of 2016.
Right, my case was filed before that. My brief was filed before that.
Okay, all right.
Right. And then lastly, number 6, to remand the trial court to use an appraisal from a disinterested person, which was repeatedly cited in the docket and which was ignored by the trial court. I'd like to reserve the rest of my time for rebuttal unless you have questions. Thank you.
You have, Mr. LaCava, you have 10 minutes remaining, but you can only reserve 5. So unless you want to continue, I'm going to stop the clock and pick you back up at 5.
I can be as verbose as you need me to be.
Okay, well, it's up to you. It's your
Okay, well, let me thank you for that, for letting me know that I have 5 more minutes. So I'd like to go through the 4 elements that are necessary in order for items to be exempt, according to 2329.66. 1, you have to be domiciled in Ohio. There's no argument there for both my wife and I. Number 2, items have to meet the description in the category of 2329.66, A4A, which in generally saying there's household furnishings, there's household goods, appliances, clothing, and so forth, that are primarily used for the family, my daughters, and for personal consumer use. Again, clearly, those items are in the inventory list. The pictures are also included, and the law requires that I just give, if I believe they're exempt, to give my reasons, which I did in the docket. And again, what reasonable minds can conclude that these are household items. I gave the chair example. We could do the sofa example. I mean, we can go right down the list and bore you to death.
Let me ask you a question. The 24 items, you stated that you're asking the court to reverse the sheriff's sale that the court already ordered. The sheriff's sale hasn't occurred yet, correct?
Correct.
Okay, so can you explain to me how this is a final appealable order?
The court order is a final appeal order to that they declared the items were not exempt, which is not following the law, and they declared the execution, the sheriff's sale, which there were no appraisals, and you can't do a sale unless it's over the statutory dollar amount. They don't know what the statutory dollar amount is because they didn't do an appraisal. And then you can't sell it less than 2/3 of the appraised value. Since they don't have the appraised value, how can they do
None of those things
it?
have been done yet.
Pardon me?
None of those things have been done
And that's my point. They misinterpreted the law, their procedure was wrong, and their application therefore is wrong. And it's all outlined in the docket with the code, the revised codes, and so forth. So it's unconscionable what happened. It's unreasonable. And therefore, it is an abuse of discretion as well. Number 4 point is, I have to meet the procedure requirements. I claim the items as exempt. I cited the applicable Ohio laws. I gave my reasons, and I gave it to the proper authority. Therefore, all the 4 elements have been met. And the trial court misinterpreted the law, and from there, misapplied the procedure, misapplied the application, as we touched on as it continued. And again, to get specific on a few items, we have a lamp in the house. The judge declared that not exempt. How is that not household furnishings to a reasonable minds that come together to reach that decision? And that's only to be, then once that says, yes, that is exempt, then the appraisal determines it has to be over the Ohio statutory dollar amount, which would have to be over $575 in a sale of a used item, which is basically like a garage sale.
Well, it's a public sale, public auction.
Correct.
And the appraisal comes after the order, I think is what Judge Schaefer was getting to, according to the statute, does it not?
That is not correct, Your Honor. The statute is clear that once they determine they're exempt, they have to do an appraisal. If you go to 2329.091H, so H says the courts determine what portion, if any, of the property is exempt. Then it goes into the next part of I, which says, if necessary to ascertain the amount or value of the judgment of the debtor's personal property, it should be appraised in accordance with section 2329.68.
Okay, and you have 5 minutes.
Any questions? I like to reserve the rest for tomorrow. Thank you.
May it please the court, my name is Christine Cooper, and I represent the appellee UBS Financial Services, Inc. The underlying case here arises out of a judgment that UBS obtained against Mr. LaCava in the amount of approximately $200,000 back in 2010. To collect on its judgment, UBS sought to execute on Mr. LaCava's personal property. This particular appeal arises out of a ruling on a hearing held by the trial court pertaining to the execution of Mr. LaCava's personal property pursuant to 2329.091. The hearing pertained to whether Mr. LaCava's personal property was exempt from execution. The standard of review in this is whether the trial court's determination was against the manifest weight of the evidence. The trial court's determination had to be supported by competent, credible evidence, and it was. The trial court relied on Mr. LaCava's arguments, UBS arguments, and Mary Ellen LaCava's affidavit, and then all of the filings as well. I want to take a moment just to renew our motion to dismiss that we had filed back on March 10, 2016. We still believe this is not a final appealable order. The order appealed from was an order allowing UBS to continue execution proceedings. It's not final and appealable until a confirmation, an order of confirmation is issued, because up until that point, the sale process and everything leading up to it can change. I also want to quickly outline what's not pending in this case. Mary Ellen LaCava, Mr. LaCava's wife, is not an appellant. That was based on the April 13, 2016 journal entry. Her consolidated appeal was dismissed, and so she is simply not a party to this appeal at all. Any assignments of error also pertaining to her are moot. The trial court, after this appeal was filed, but after the consolidated appeal was dismissed, granted her motion to intervene. While UBS believes that that was incorrect on jurisdictional grounds, UBS did not oppose the motion to intervene, and so according to the trial court, she has now intervened in the action. Just to run through some facts, judgment against Albert LaCava in the amount of almost $200,000. It was a domesticated judgment in Summit County, and UBS requested a writ of execution on personal property issued by the clerk, which was issued by the clerk. So under the statutory scheme, the trial court and UBS have met all the requirements to date. And I say to date because there are still processes that need to happen, which is why I believe we're here prematurely. UBS filed the precipice for writ of execution. The clerk issued the writ. A notice and hearing request form was served on Mr. LaCava. He requested a hearing, which he had right to do, and that hearing was limited to the amount of property exempt under 232966. The hearing was held on November 19, 2015, and at that hearing, Mr. LaCava had the burden to show that the property was exempt from execution. The trial court determined that at that hearing, he had not established that fact, that anything was exempt at that time. The court instructed the sheriff to take an inventory of the personal property, and that happened on December 2nd, 2015. Then, what the court did, the trial court went above and beyond its requirements under the law. It allowed Mr. LaCava to renew his objection, which he did after the inventory was taken. So now there's a list of items of personal property, and Mr. LaCava was allowed to present new evidence as to why those were exempt, why those items were exempt. The trial court, well, Mr. LaCava argued two things. One, that Mary Ellen LaCava, his wife, owned 24 of the items and 50% of all the remaining items. Mr. LaCava also argued that he was entitled to an exemption under 232966 because he did not believe that any of the items would sell for more than the statutory limit. He provided no appraisal, no evidence of what the actual value of those personal property items were, just his belief. So basing its decision on the...
And they hadn't been appraised.
They had not been appraised, and let me talk about that. Under the statutory scheme, there are really two ways that this could be appraised. One, it could be appraised prior to the sale appraisal under 232968. But what has to trigger that appraisal, and that's done by two disinterested parties, is Mr. LaCava would have had to expressly request that, which he did not. He never requested 232968. So the court never had a reason to issue that appraisal. If you look at the Esterhaus case, which Mr. LaCava relies on for the idea that he was entitled to an appraisal prior to the order of sale appraisal, I went back and looked at the docket in that case, because the case itself isn't 100% clear. But in that case, the party did, in fact, on a motion, request a 232968 appraisal. Now, the other way to get the appraisal is once the order of sale is issued, your normal process, what we would normally see. The three disinterested parties come in, appraise the property, and then a share of sale is set. In this case, no share of sale has been set. We just haven't gotten that far. So, basing its decision on the filings in the case, Mary Ellen LaCava's affidavit, and an evidentiary hearing, which was held, so you have the November hearing, then you have one in January of 2016, the court drew three conclusions. One, Mr. LaCava did not establish a 232966 exemption because third-party ownership, for two reasons. Third-party ownership, such as that of a spouse, is not an exemption under that statute. Neither is co-ownership. Mr. LaCava, the second conclusion that the court drew was that Mr. LaCava did not offer any evidence as to the actual value of the items. He had the burden to show that the items were below the $525 per item, or in the aggregate, the $10,775.
Would he have had to hire his own appraiser to come up with those values?
Well, he could have triggered the 232968 to get the two disinterested appraisals, but then he would have been stuck with it. Or he could have hired his own.
So he had a statutory
He did have
method to make that happen.
Yes, he did, Your Honor. The third conclusion that the trial court drew was that if Ms. LaCava had an interest, she had to file a claim under 232984 after the property was levied, or she could redeem it by paying half the highest offer at any sale. Now, 232984 is a really interesting statute, actually, for an execution statute, because what it does is it triggers essentially a mini-trial. Had she either filed a motion to intervene or sought relief under 232984, what that would have done is triggered a jury of 5 to determine the ownership of the property. And it's all set forth in the statute, and there are some cases that also interpret that. One particular case, which Mr. LaCava actually cites, is the Skybank versus Leonard and Associates case. It does a very nice job outlining 232984 and sort of the mechanism and how it works.
So that can still happen in this case?
That could still happen in this case. Well, not the 232984, because the time would have run on that. It's a very short time limit. So sheriff shows up to the house. She really needed to say, that's my property. Sheriff comes back. Within 3 days, everything is triggered and that trial is held.
You said there was a motion to intervene that was granted.
Yes, and so her motion to intervene has been granted. Now she is part of the case, and, you know, it's a long time limit for her to assert her ownership interest, so it's not using the statutory mechanism.
Is she out of
It's using
time? Is she out of time to assert that now?
Her motion to intervene? No, I think she has the right to intervene in the case.
I want to make sure I'm clear on this. I thought you said she was permitted to intervene.
She was.
Okay.
What she can't do now is use 232924, which would prompt the mini trial. Now we're under your standard, file a motion to intervene, typical evidence. You're not pinned into 3 days, basically, and 5 members of the jury. Now she has to prove her ownership in a more standard way, I suppose.
Are you going to address the supplemental authority?
Oh, sure, I absolutely can address the supplemental authority. So, in that case, that's the In re Steimer case, the issue there was whether the debtors were entitled to an exemption in insurance proceeds paid to reimburse them for a loss of personal property. It really doesn't have anything to do with the issues in this case. As it pertained to third parties attempting to claim some of those insurance proceeds, the court found that there was no evidence that the third party made any claim on the proceeds. So it's in a bankruptcy setting, and what the debtor was essentially trying to do was shelter the full amount, or as much as they could, of insurance proceeds after I think their house had a house fire, and so a lot of their personal property was lost. And it was really poor timing of the filing of the bankruptcy, because they lost a lot. What the court ultimately held was that the debtors could only claim an exemption in the statutory amount on those insurance proceeds. So that was the In re Steimer case. That was the whole In Steimer case. So I want to go quickly through the assignment of errors as laid out by Mr. LaCava. Number 1 and number 2 are that the trial court violated Mary Ellen LaCava's due process rights by failing to consider and address her affidavit. And number 4, the trial court erred in not granting Mary Ellen LaCava her statutory exempt status on household items. Those 3 assignments of error fail for the same reasons. They should be overruled because Mr. LaCava does not have standing to prosecute and appeal to protect a third party. Ms. LaCava's constitutional rights. He does not have standing to protect those rights. He does not meet the City of East Liverpool test. There was no injury that he sustained as a result of the purported violations of Mary Ellen LaCava's rights. His rights don't change. He has no entitlement, if the sheriff's sale went through, other than the exemptions, because it would be an execution on his property, he loses the right to his 50% or whatever else he owns under the statutes. There was no hindrance that stood in the way of Ms. LaCava seeking any remedy. She could have filed an affidavit, or she could have filed under 232984, and she did in fact file a motion to intervene. So her rights to date have not been violated, and he would not have standing to assert that anyway. Assignment of error number 3 is that the trial court erred by associating exempt status of household items with a price value for the items. The trial court had no choice but to associate a price. It had to evaluate whether the statutory exemption under 232966, that $525 or the larger amount in the aggregate, was met. And the only way to do that is to associate a value. There was no evidence as to value, so the trial court assumed, until it gets an appraisal, that all that was still fair game for execution. Assignment of error number 5 was that the trial court erred by not ordering multiple independent appraisals before a sale order. We've talked about this. This should be overruled because the appraisal requirement has not been triggered yet. Mr. LaCava didn't request one under 232968, and we're not quite there on the order of sale yet. So the order of sale was issued April 1st, 2016, but as the appeal was ongoing, a motion to stay was filed and the court granted that.
So the trial court issued an order for sale while the appeal was pending?
Correct, because no stay had been sought and no bond had been posted. So the execution proceedings continued. So there is the order of sale pending, but it's been stayed appropriately under the motion to stay and the requirements. If this appeal is overruled, then the appraisal requirement of 232915 would be triggered, and the 3 disinterested persons would come out and appraise the property, and then we would know the value and whether 232966, where everything fits. The other,
Just so
Yes.
I understand,
Yes.
because this is so messed up procedurally. Because I know, the wife has filed the motion to intervene was denied, after the appeal was pending.
yes, that's correct. The original one was denied because of the appeal.
And, so I guess I'm wondering, and I know you filed multiple motions in regards to this, if this is not a final bill of order, what is your opinion as to when it would be? I want to make sure I understand.
I think it is a final appealable order upon the confirmation of any sale. If there is property that was ordered to be sold, that was improperly sold, at that point in time, the LaCavas would have a remedy. Because at that point, title hasn't shifted until the decree of confirmation goes on, and you still have time before it shifts, and that's when they would have to assert their appeal right.
And that would be in between the time, that's a difficult position to be in.
It is a difficult position to be in, but I think what we can say is clearly where we're at now, where we haven't had an appraisal, we don't know the price of the goods or the value of the goods specifically at this point. We're clearly not to the phase where we have a final appealable order yet.
So you're saying you appeal and then before title passes, and then obviously you have to ask for a immediate stay.
Yes, correct. And once the sale occurs, there's that 30-day limbo period really that you have in there before the decree of confirmation would go on, and there would, I'm sure, be motion and practice involved in that if Mr. LaCava felt as though the property was wrongfully taken or wrongfully sold. And I would point your attention to the case that addresses this is that Bank One versus DWT case 2006 Ohio 7271. It talks about when in the process the order becomes final and appealable.
And with that, you're right.
Oh, thank you very much.
Mr. Powell, yes, we still have 4 minutes.
I'm sorry, Your Honor, you're saying I have.
Just over 4 minutes.
Okay. Many of the comments and statements made by the opposing counsel were deceiving and quite outright lies. They have been aggressively opposing my wife's motion to intervene. She had, from day one, she filed her claims and had been denied again. It goes back to the trial court misinterpreting the law, and from there, it just left the planet. Misapplied and went all the way through. On the appraisals, I cited the statute for appraisals on the first filing, repeated the file for appraisal. The court ignored those. Okay, and I stated in my comments how appraisals have to occur first. And then the fundamental issue of what's exempt, by definition, is, again, clear to any reasonable mind, that together we come to one conclusion. All those items are exempt. How is the kitchen chair not exempt? And so that just threw everything off. And the whole, you're right, the procedure has been totally screwed up, but because they didn't interpret the law to begin with correctly. The burden is not on me to determine the value. In fact, if you go to the Steimer case does apply, and it says that Ohio is an opt-out right state. So consequently, the Ohio exemptions set forth in Ohio Revised Code 2329.66 apply. So this court is applying the Ohio statute of
That's
exemptions.
something about bankruptcy law. You can either follow the federal exemptions, or a state can opt out of the federal exemptions, have state exemptions apply, which Ohio did, correct?
Correct. So this exact statute applies, and it says, and I quote, "The objecting party bears the burden, UBS bears the burden of proving that the exemptions are not properly claimed." All I have to do is state my reasons, which is in the statute, which I did, it's in the docket, and that's it. The judge then makes a decision on what's exempt, because every person has exempt property from execution or sale. And from there, he screwed everything up, quite frankly. And then did do the appraisals. By the way, I submitted a supplemental for the appraisals. While I saw this whole thing going way off course, not following the law, I did pay for a disinterested person to do an appraisal, and every item is under the exemption dollar amount. Just on that basis alone, there should be no sheriff's sale. It's filed in the docket, and it was a professional appraisal that had no interest in, or no relationship with either party.
When was that filed?
That was filed in the spring of 2016.
Before this appeal?
It was after the appeal, because I had been asking the court repeatedly to do the appraisals. It was in my docket, in my filing, in my arguments, and they just ignored it, nor did they give me any indication that they were gonna totally disregard it.
So they
And then,
couldn't do anything about it once the appeal had been filed, could they?
the court has a lot of power, they can do what they want. They're supposed to follow the statutory law, and they didn't. So I went ahead and paid for one on my own. I moved that the court reimburse me for that. There's nowhere where I have the burden of having to get an appraisal. I just proved the burden is on them to show it's not exempt. It says the court has to order the appraisal. Nowhere does the defendant have to order the appraisal or pay for an appraisal. And that, again, is another deceptive statement. So, you know, when they say, and they make comments with no legal authority whatsoever. They're just headline opinions. And so, again, we're back to, what way you look at it. All the items are exempt. All the items are under the statutory dollar amount, which is filed in the case now. No sheriff's sale should occur. My wife's been trying to intervene from day one, and UBS has done everything they can to confuse the court to not let her intervene. That's a major violation of the 14th Amendment of the Constitution.
And we will take tomorrow time, and we will take a look at that. So, thank you for your presentation today, Mr. LaCava. And we will take a matter of advisement, and issue a written decision which will be available to both sides as well as posted to our website and the Supreme Court.
Thank you, Your Honors.